Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Legal Scrubs. Today I want to talk about physician non-compete provisions. If you are a new physician just coming out of residency and are looking for your first employment relationship, you're going to be presented with a form employment agreement by your prospective new employer, whether it's a hospital system, a single hospital, whether it's a small or large physician practice, whatever, you're going to be presented with an employment agreement. And one of the key provisions in your employment agreement is the non-compete provision. Essentially, a non-compete has terms that restrict the physician's right to practice his or her profession, to practice medicine for a certain period of time in a certain geographic area when that physician leaves the employment relationship with his or her employer. So, for example, if you join a group practice in a particular area of the state of Tennessee, and you sign an employment agreement that has a non-compete provision in it, and you are either terminated or you decide to leave, or the term of the agreement just expires. If it's a 1 year, 2 year, 3 year agreement, that you work there and then the time runs out, it's not renewed, you're ready to leave, and you look at your contract and there's this provision that says you cannot practice medicine in the area for 1 or 2 years. And so, wow, you have moved to the area, maybe bought a house, settled down, and now you have this non-compete provision. So, non-competes are very, very significant provisions in an employment contract. Now, it could be that you are a doctor who has been in practice for a long time, and your group just requires that you every year or 2 or 3 you sign a new employment agreement, and it may provide for a non-compete as well, even though you may have practiced with that group for a long time, and for whatever reason you decide you want to leave. Just like the young new doctor who moves into town and signs his or her first employment agreement, you've got a problem, because if your employment agreement has a non-compete provision, you are going to have a problem practicing medicine in the area that perhaps you've been settled in and gotten known in and have a large patient base in. You also are going to have a problem because of the non-compete provision. Now, in Tennessee, non-compete provisions in employment contracts for physicians are deemed reasonable by statute if they don't exceed in time more than 2 years. So that's the outside limit. If you have a non-compete that's more than 2 years, it's too long under the Tennessee statute, but it could be as long as 2 years. The statute also deems reasonable a non-compete that has either a geographic limitation that is no more than 10 miles from your primary practice site or the county in which you practice, whichever is greater. So if you are practicing at a particular location and 10 miles away from that is outside the county, the 10-mile limit would be greater than the county line. So that the greater would be the 10-mile limit. So you would restrict it to that 10-mile limit. If you go 10 miles from your primary practice site and you're still within the county, and if the restriction is for the entire county in which you practice, then that would be valid as well, because the greater of the two, the 10 miles or the county, is the county line. Now, it's also possible that a non-compete in Tennessee, rather than having a geographic limit like 10 miles from your primary practice site or the county, whichever is greater, may have a provision that says that you cannot practice within, you cannot practice at any facility that your employer, your former employer in this case, provided services during the term of your contract. So, for example, if you're in a group that has multiple sites maybe throughout the area and practices at a number of hospitals, provides services in a number of hospitals, if you had a contract that said that you're restricted from providing services at any facility at which your employer or former employer provides services or provided services during the term of your contract, that would mean that you could not provide services at those hospitals. Now, it may be that you're in a kind of practice that you don't provide services at hospitals generally, and you have a strictly clinical, in-office type of practice. If that's the case, then a restriction that just limits you to facilities at which the practice provides services may not be of any concern to you. And it's more likely, if that's the case, that your non-compete's probably going to have that 10-mile or county line kind of restriction. So, bottom line, if you are either coming out of medical school, or coming out of your residency, getting ready to start your first real job out of residency in private practice, and you're presented with an employment agreement that has a non-compete, you need to take time to look it over, make sure you understand it, make sure you're good with it, because you're going to be moving to an area, perhaps settling down, developing a practice, and you don't want to be overly restricted from practicing in that area when you leave your first job, which you might do. Similarly, if you are an established physician who has been in practice for a long time and your group regularly presents you with an employment agreement, you want to make sure you look at and understand and are comfortable with the non-compete provision in your contract. It could be that you could negotiate it away or even negotiate it so that when you've been in practice for a certain number of years at the group, that the non-compete goes away. In all events, make sure you look at your contract and understand the non-compete and are comfortable with it. You probably should seek legal assistance to review the contract, make sure you understand it. Now, if you have a non-compete provision in your contract, your employment contract, and you decide to leave, what can you do? Well, again, because of the statute in Tennessee, non-compete provisions that fall within this range of reasonableness, which is the 10-mile or county size, whichever is greater from your primary practice site or the facilities at which your group practices, and no more than two years, those kind of provisions are deemed reasonable. So you kind of have an uphill battle to attack or challenge a non-compete if it has those deemed reasonable provisions in your non-compete. However, it may be possible for you to, if it's the case that this non-compete does not serve a legitimate business purpose or business reason for the practice. For example, you don't have any kind of confidential information that could be of any detriment to that practice for you to compete with them. You may be able to challenge a non-compete based on a position that the non-compete does not serve a legitimate business purpose for the practice, because non-competes in general are disfavored by courts because they are a restraint on trade and business. And so a non-compete is not intended or shouldn't be intended to restrict all competition, but just unfair competition. So if you don't have certain inside information, or there would be some detriment or harm to the practice because you're competing with them other than just normal competition, you may be able to challenge the non-compete. It could be an uphill battle, but again, talk to an attorney who can advise you on your particular non-compete and your particular situation. All right, I hope that helps. The key takeaway from today is non-compete provisions are one of the key provisions in your employment agreement, along with your compensation and maybe a certain lifestyle issues about taking call and also tail insurance provisions on when you leave a practice. Those are sort of the key provisions, but a non-compete is absolutely one of the most important provisions in your employment contract. Make sure you are comfortable with it. Make sure you understand it. Make sure you're not just signing something and then are going to regret it later because you didn't think about it or take it into account before you signed your agreement. Okay, that's it for today's episode of Legal Scrubs. I hope it helps. If you have any questions, please feel free to give me a call.